You need to hear this, because the Supreme Court just dropped a bombshell, a 9-0 unanimous ruling that completely reshapes how the Fourth Amendment is interpreted when it comes to excessive force by law enforcement. We're talking about protections against unreasonable searches, seizures, and yes, deadly encounters. This isn't just another dry legal update. If you're a lawful gun owner, if you care about your personal rights, this one matters, because this decision changes how courts across the country must analyze situations where police use force. And trust me, you'll want to know exactly what's shifting. Now, let's dive into the meat of this case, because this ruling doesn't just tweak the law. It rewrites how officers, courts, and citizens have to think about force and accountability. The heart of it involves a tragic incident in Texas. Officer Roberto Felix Jr. pulled over a man named Ashton Barnes, suspected of toll violations flagged by cameras. Nothing major, at least that's how it started. But the situation escalated fast. During the stop, Felix ordered Barnes out of the vehicle. Barnes opened the door, appearing to comply, but then tried to drive away. Within seconds, chaos erupted. Officer Felix leapt onto the open doorframe as the car moved and in just 2 heartbeats fired 2 rounds at Barnes. Barnes was hit. He managed to stop the car, put it in park, but the wounds were fatal. And that's where the legal storm began. Barnes's parents sued Officer Felix, alleging he violated Ashton's Fourth Amendment rights by using excessive force. The district court didn't see it that way. Using the Fifth Circuit's infamous moment of threat rule, they ruled in Felix's favor, saying courts only needed to examine whether the officer was in danger at the precise instant he fired, not what led up to it. Sound narrow? It was, and the Fifth Circuit doubled down, affirming the decision. Felix was clinging to a moving car. His life was reasonably at risk. Therefore, the shooting was lawful. Case closed, at least for a while. But then the United States Supreme Court stepped in, and what they said will change how every similar case gets judged from here on out. The moment of threat rule destroyed. The Supreme Court didn't just review the case, they dismantled the entire foundation of the Fifth Circuit's reasoning. In a 9-0 unanimous ruling, they flat-out rejected the so-called moment of threat rule. Here's what they said. When evaluating claims of excessive force under the Fourth Amendment, courts can't isolate a single frozen instant. They can't just zoom in on those 2 seconds when Officer Felix was hanging off a moving car and ignore everything that led up to it. Instead, the court ruled that the use of force must always be analyzed under the totality of the circumstances. That means you have to step back and look at everything. The lead-up, the choices made, the threats perceived, and whether the officer's actions were objectively reasonable from the perspective of a reasonable officer on the scene. This is huge, because under this new framework, cases like Barnes's don't get boiled down to 2 seconds of chaos. They get evaluated in full context. The court made it clear, excessive force claims fall squarely under the Fourth Amendment. And when you're judging reasonableness, there's no shortcut. Every relevant detail matters. Every decision leading up to the moment matters. But they also left one thorny issue dangling. What happens when an officer's own actions create the danger in the first place? If Felix's decision to leap onto the moving car escalated the risk, should that affect whether his use of deadly force was reasonable? The Supreme Court deliberately sidestepped that question, punting it back to lower courts to wrestle with in future cases. Meanwhile, some justices filed concurring opinions to highlight the dangers officers face during traffic stops. Kavanaugh, Thomas, and Barrett, among others, pointed out the harsh reality. Traffic stops are among the most dangerous situations for law enforcement nationwide. Officers die in these encounters far too often, but even with that acknowledgement, the court sent a loud message. Danger alone doesn't grant officers unlimited authority to pull the trigger. You can't just invoke, "I felt threatened," and bypass constitutional protections. The facts, the context, the entire situation now carry weight. And for lawful gun owners, this matters more than most people realize. Because this decision redefines how courts will evaluate deadly force encounters, especially in situations where you're lawfully armed and interacting with police or federal agents. Why? Because many of the most controversial shootings involving lawful gun owners happen during chaotic, fast-moving moments: raids, surprise searches, traffic stops gone wrong. Before this ruling, courts often narrowed their analysis to the exact second when shots were fired, giving officers an enormous advantage. But now that's gone. From this point forward, the totality of the circumstances will dominate excessive force litigation. Every detail, the warnings given, the officers' tactics, whether they identified themselves properly, can now sway a case. And this decision doesn't just affect lawsuits, it also ripples into how agencies train officers, how prosecutors handle cases, and how much legal risk individual officers take on every time they escalate a situation. But there's another wrinkle you need to understand. The Supreme Court didn't resolve Barnes's case outright. So where does that leave us now? In limbo. The Fifth Circuit has the mandate, but they haven't reopened the case yet. The next moves are entirely up to them, whether to rehear the arguments themselves or send it back down to the district court for a brand new trial. And while we wait, something bigger is happening behind the scenes. This ruling is already reshaping how courts across the country interpret your Fourth Amendment rights. Mass design is a textual topic, known, likely stayed, turnation, it's spreading power. Thank you for watching. Thank you for getting involved. Support of no understand. Is this time is high? It's turned to this. When gun owners collide with law enforcement, this case doesn't just touch police tactics. It hits the heart of a growing tension between lawful gun owners and aggressive law enforcement practices. And if you carry, own, or even store firearms legally, you need to understand how this decision could affect you. Here's the uncomfortable reality. A disturbing number of shootings happen when law enforcement officers don't clearly identify themselves, especially during raids, nighttime entries, or chaotic traffic stops. Imagine this. You're at home, it's 2 a.m, and someone kicks in your door. You're a lawful gun owner. You grab your firearm, but the people coming through aren't announcing themselves, and you have no idea they're federal agents. Now imagine what happens when you exercise your Second Amendment rights in that situation and fire to defend your family, only to find out afterward that they were agents executing a warrant. These are the types of cases where the totality of the circumstances analysis matters more than ever before. Before this ruling, courts routinely gave officers the benefit of the doubt, zeroing in on the exact moment shots were fired and ignoring the context leading up to it. But now, context is the law. Think about how this plays out in states like California, New York, and Illinois, places where aggressive enforcement collides head-on with restrictive gun laws. If officers fail to identify themselves properly and a lawful gun owner reacts, courts are now required to look at the entire picture. Did the officers announce who they were? Were they following proper warrant procedures? Did their own actions create unnecessary danger? And did the citizen have a reasonable belief they were under threat? This ruling could mean the difference between a citizen being convicted or walking free. It shifts power back toward analyzing fairness, not just freezing a moment in time. And here's where it gets even more personal. Many of the cases impacted by this ruling involve lawful gun owners shot during encounters with police or federal agents, especially ATF raids. We've all seen the headlines. Agents, officer felt threatened. End of story. But the Supreme Court just blew that logic apart. Now, plaintiffs can argue that everything matters. How fast things escalated, whether de-escalation was attempted, what commands were given, and if the officer's own decisions pushed the situation toward deadly force. And make no mistake, this doesn't just affect lawsuits. This ruling is going to influence training manuals across the country. Departments will have to teach officers to think ahead, manage risk, and identify themselves clearly, or risk losing in court. It also reshapes how attorneys argue self-defense for gun owners. Because if an officer fails to follow proper procedures and a lawful citizen responds reasonably, courts will have to weigh that entire sequence, not just the split second of gunfire. Bottom line, if you own firearms, this decision could very well change how your rights are protected or violated during encounters with law enforcement. And in states where tensions between citizens and agencies are already high, expect this ruling to spark new legal battles in the coming months. But we're not done yet, because what's happening in the Fifth Circuit right now could set the next big precedent. If this case goes back for a full trial, it could redefine how far the courts are willing to go to hold officers accountable for violating your rights. The battle isn't over. Right now, the Barnes case is sitting in a strange legal limbo, and what happens next could shape Fourth Amendment rights for decades. The Supreme Court sent the case back to the Fifth Circuit with a clear mandate: start over, reevaluate everything using the totality of the circumstances. But here's the problem. The Fifth Circuit hasn't reopened the case yet. The judges have two options: rehear the arguments themselves or kick it back to the district court for a full-blown retrial. And there's another twist. The man fighting this legal war is Ashton Barnes' father, representing his son's estate pro se, while sitting in prison. Think about that for a second. He's drafting motions from behind bars, filing petitions by hand, and trying to convince the courts to act on the Supreme Court's ruling. Until the Fifth Circuit makes its move, the entire case is on pause. But here's why you should care. The ruling already changed the rules nationwide. Every excessive force lawsuit in the country now operates under the totality standard. That means police departments, federal agencies, and even prosecutors are recalibrating strategies as we speak. If you've ever wondered how high-stakes legal decisions trickle down to everyday gun owners, this is it. Here's what shifts immediately. Citizen lawsuits gain leverage. Before, officers often won early dismissals under the moment of threat shortcut. That's gone. Now, plaintiffs can force courts to dig deeper. Police training will evolve. Officers will need to carefully justify their choices, not just at the moment of firing, but throughout the encounter. State-by-state clashes will intensify. Restrictive states like California and New York will face waves of new lawsuits from citizens claiming their rights were trampled during raids, searches, or stops. Second Amendment intersections get messier. With ATF raids, unannounced searches, and aggressive enforcement in focus, lawful gun owners now have a stronger legal foothold if things spiral into deadly confrontations. And here's the part nobody's talking about. This ruling could fuel massive debates about qualified immunity, the doctrine that often shields officers from personal liability even when they violate constitutional rights. If courts are forced to scrutinize the full context of an encounter, we could see more challenges to qualified immunity than ever before. But don't mistake this for a magic shield. This ruling doesn't mean citizens automatically win. It means the fight gets fairer. It means judges and juries must now consider everything. Did officers identify themselves? Did they follow protocol? Did their actions escalate the danger? For gun owners, that's critical. If an ATF agent raids your home at night without announcing themselves and you respond believing you're under attack, the court must now weigh your perception of the threat, not just the government's narrative. This ruling empowers citizens to demand accountability. It forces law enforcement to rethink aggressive tactics, and it rebalances a system that for years leaned heavily in favor of officers, especially in split-second shootings. As for the Barnes case itself, we're watching history unfold in real time. If the Fifth Circuit orders a retrial, we could get one of the most influential verdicts in recent memory, a case that could further clarify the limits of force, the duties of officers, and the rights of citizens. Until then, all eyes are on the Fifth Circuit. And if you think this fight is over, think again. It's only just begun.